Welcome to Legal Lines. My name is Tom O'Shea. I am the host of this program, brought to you by the York County Bar Foundation. The York County Bar Foundation is the charitable arm of the York County Bar Association. And today's guest is Ben Hooper. Ben is the managing attorney at Mid-Penn Legal Services York office. And tonight's topic is landlord-tenant law. And Ben handles a lot of landlord-tenant cases, so that's why you're here. So welcome, Ben.
Thank you. It's great to be here.
Thanks. And what we're going to talk about first are the types of leases that a tenant would have with a landlord. Now, I want to make it clear we're speaking today solely about residential landlord-tenant law. I know there's also commercial landlord-tenant arrangements. We're not going to focus on that at all, but instead residential landlord-tenant law.
Right.
Go ahead.
In Pennsylvania, there are two types of arrangements that are recognized. One is a term tenancy, where there needs to be a written lease agreement. This is when you have a tenancy for a certain duration of time that's specified, January 1st until December 31st. The other major type of tenancy that people have is called a periodic tenancy, or commonly referred to as a month-to-month. If there's any confusion as to which kind of arrangement you have, the law is going to default and recognize that it's a periodic tenancy. And the periodic tenancy differs from the term of years because it's indefinite. It just keeps renewing whatever the period is.
So when you commonly use month-to-month, it's because most periods are month-to-month, but there might be a situation where, for example, it's week-to-week.
And conceivably, you could have a year-to-year tenancy, but right, probably 95% of residential living arrangements are month-to-month tenancies. The other 5% are probably week-to-week.
Okay. Now, one of the things that I think needs to be clear is that in many cases, the arrangement between the landlord and tenant isn't in writing at all. It's oral.
And that's fine. A lease agreement is defined by statute, and it can be implied from the circumstances. It can be a written agreement. It can come from an oral agreement. I think one thing that's very important to know is that when you have the periodic arrangement or month-to-month, either side can terminate that at any time with the right amount of notice. But without any reason, you can have a bad reason or no reason at all or a good reason.
Well, if you're the tenant and you say, well, I have this apartment and I'm leasing it now and I want to move to a larger apartment or I'm buying a house now, you can let the landlord know that you're not going to renew the lease, if you will. And if it's a month-to-month, a verbal lease, you have to give, what, 15 days notice?
I should say too, you can have a written lease agreement, and it can say it's periodic. But what the law requires is 15 days notice from either side prior to the expiration of any term. So if it's month to month, you pay your rent on the 1st. The notice needs to be in by the 15th of the month.
So really, if I was renting an apartment for myself and had lived there for, let's say, 10 years, I can be told I have to leave in as little as 15 days?
That's right. That's correct.
Well, that's pretty short notice. I thought it was at least 30 days. So
one exception we should make clear too. We're talking about residential apartments. The law does differentiate if it's a manufactured home park, a mobile home park. In that instance, you do have a right to renewals of the lease term, even if you're a periodic tenant. And you have a right to be offered, the landlord is obligated to offer the tenant a written lease agreement on an annual basis. The reason for that is even if you've lived in that apartment 10 years, it's going to be a hardship if you've been there a long time to move on such short notice. If you're in a manufactured home park where you own the home, then if your lease arrangement ends, you're trying to make arrangements to move the home, which of course
it's not just moving all your furniture, it's moving the mobile home itself and finding a place to put it. So how much time is needed there?
I believe that 60 days notice has to be given, but again, the main point is you're entitled to an automatic renewal. And that's the major differentiation we're making here too between periodic tenancies in terms of term tenancies. If you sign a term tenancy for a year or more, you have the right to stay for that entire term unless the rent is not paid or a lease obligation is not met.
Somebody breaches the lease.
A
But
material-
assuming you're paying your rent and the landlord is providing the services the landlord promises to pay or to provide, then you have the right to stay for the term. So if you sign a lease that said you had 1 year, the landlord cannot give you 15 days notice after 6 months.
Correct.
Okay, you have the right to stay for the full year. And by the same token, the tenant can't just say, well, I don't like living here anymore, I'm going to move out. The tenant is still responsible for the rent for the rest of the term.
Correct.
Okay, now at the end of a written lease, and I know this happens frequently, the tenant and the landlord don't bother to sign a new written lease. Does it automatically convert to month, or does it go back to the same period as the original term?
Well, it's going to convert into a periodic tenancy unless the language in the lease agreement says otherwise, and sometimes it does. You can have a provision in the lease that the landlord and the tenant agree to that the lease will renew to another 1-year lease term unless either party gives notice.
So it's important to know the terms of your lease before you decide what you're going to do. Let's say I'm renting an apartment for 1 full year. I plan to stay for 3 more months and then leave. I better renegotiate my lease with the landlord for those 3 months as opposed to just renewing for a full year.
You know, and I do meet clients who don't have a copy of their lease agreement, so it's important to read your lease agreement and know what it says. And when you begin a new tenancy too, get a copy of the agreement that you just signed. The landlord often, of course, is going to maintain a copy. I want to move back a second to give a caveat to what we talked about before, the point you made. If there's 6 months to go on the term and you want to move out, you're obligated for the future rent. A landlord will have the duty to mitigate the landlord's damages, and what that typically just simply means is the landlord's going to try to re-rent that apartment.
And if the landlord does re-rent the apartment, the landlord's not entitled to rent from both the former tenant and the new tenant.
Correct.
So the duty to mitigate damages really is that the landlord has a duty to use good faith to try to find another tenant.
Reasonably commercial means, right, to try to yeah.
Okay. But nevertheless, it's best when you comes to renew the lease to know the terms of your written lease if you have one, or to communicate clearly with the landlord as to what the new term is going to be.
Correct. And that's something that might be glossed over when you're first, both by the tenant and the landlord, when you first...
Right, but if there is a written document, basically what we're talking about is contract law, and we're going to follow what the contract says.
Correct.
Okay. Now, the other things that I know most landlords insist upon is something known as a security deposit. Is there a dollar amount that is a limit for what a landlord can charge for a security deposit?
There is, and that's 2 months' rent. There are some caveats here too. There are rules that say after the first year of a tenancy is completed, then the limit goes down from 2 months to 1 month. So after the first year, a month has to be refunded. If it's a long-term tenancy, after the second year, the tenant then becomes entitled to interest on the security deposit. So after the second year, then the landlord is required to put the money in a interest-generating account for the landlord. The landlord can deduct 1% of the interest to cover administrative expenses.
Okay. Now, let's say that you rented an apartment for a year. You paid a 2-month security deposit. You are ending your lease at the end of the year. What right do you have to get 100% of your security deposit back? Because I've heard stories where people complain that the landlord's keeping some of their security deposit.
Well, first off, what we like to see at the inception of the tenancy, at the beginning, if the landlord's going to require a damage deposit, it's not mandatory, but of course many do, is for the landlord to provide the tenant a move-in sheet so that the tenant can document any pre-existing damage. At the end of the tenancy, what we like to see, what we recommend to both sides, is that they meet and do a walkthrough, so that the tenant can have the opportunity to know where the tenant stands and see if there are any problems. The tenant could potentially try to remedy and any damages the landlord points out. The tenant's general responsibility is to return the apartment to the landlord in the same condition in which the tenant found it, which generally means clean. Is
there some language about reasonable wear and tear, or
Well, that's right. A landlord is responsible for maintenance of the building, big structural repairs, things like that. Tenants are not generally responsible for ordinary wear and tear, so things like
the carpet being worn down,
frayed a little bit, right,
from when it was a year ago.
Faded paint,
right.
That's not the tenant's responsibility.
So the landlord can't say, I'm not going to give you your security deposit back because I'm going to repaint.
Correct.
Unless the tenant damaged the paint or wrote on the walls or did something like that.
Yeah, anything that's caused by tenant abuse or neglect is the tenant's responsibility.
But that's what they're allowed to use the security. The landlord is allowed to use the security deposit to pay for the cost of damage.
Correct. And by law, a damage deposit can be applied to unpaid rent if that exists. It's the tenant's responsibility to provide the landlord with a forwarding address at the end of the tenancy.
To send the security deposit refund back to the tenant.
Right. Well, the landlord's obligation is within 30 days from the end of the tenancy to do one of two things: either return the deposit to that forwarding address, or give a statement to the tenant and explain where the security department is being applied to what damage. And often, if it could be some of both, a partial return of the deposit and some explanation of damages.
One of the things that I'd also like to talk about briefly before the break is that there's a fair housing law that exists where landlords cannot discriminate.
Yeah, I suppose that's a caveat to what we were saying before about you don't need a reason to end a tenancy.
But you cannot do it for an illegal reason.
You can't do it for an illegal reason.
Like discrimination on the basis of race, religion, gender, or something that would be clear. But one of the things we talked about before the program was that under the fair housing law, a landlord cannot discriminate against people who have young children.
Correct. Most everyone knows that the Fair Housing Act prohibits discrimination in the housing arena on the basis of race or national origin, religion, gender. It also covers now disability with the Fair Housing Amendments Act and familial status. So it is illegal for a landlord to refuse to rent to a family because of the presence of children.
Okay. And I know that that's a problem for many people, is they have young children, and a landlord might be more reluctant to rent because they figure that the children will make noise, cause damage, whatever, but that would be illegal for them to discriminate. And by the way, we're out of time for this segment. We'll be back in a few moments. This is Legal Lines. My name is Tom O'Shea, and I'm here with Ben Hooper from Mid-Penn Legal Services. Thank you. Welcome back to Legal Lines. My name is Tom O'Shea, the host of the program, and my guest today is Ben Hooper, managing attorney for the York office of Mid-Penn Legal Services. Our topic is landlord-tenant law. And in the first segment, what we talked about is different types of leases that exist and security deposits and the general obligations that the landlord and the tenant have with one another. But now we're going to talk about what happens if there are problems. And the number one problem that might exist is the tenant cannot afford to pay the rent or is not paying the rent on time. What would happen if the tenant is not paying the rent? What are the remedies available to the landlord?
Well, those are two different issues, so they're good to point out. If the landlord is not, if the tenant is not paying the rent on time, then the tenant is breaching an important provision of the lease agreement. if the landlord feels that the tenant breaches a material provision of the lease, the tenant's entitled to a notice, and if it's a breach of the lease agreement, that's a 15-day notice to quit. And what the notice to quit does is it advises the tenant that the tenancy is terminated at that point, and if 15 days down the road the tenant doesn't surrender the premises, then an eviction action can be brought in court.
So before anything can be done by the landlord in court, the landlord has to give a 15-day notice to quit, which basically means notice to either terminate the lease or
it's a vacate notice,
to
right?
vacate.
It's a termination
Now,
notice.
what happens if during those 15 days the tenant pays the rent? Is the landlord obligated to continue to rent to the tenant?
Well, let me clarify. The 15-day notice is you can do for a late payment of the rent if that's happening periodically, and the landlord isn't satisfied with that, and a few would be. If the issue is just non-payment of rent, then that's a slightly shorter notice period. That's a 10-day notice to quit for non-payment of rent. 15 days if it's any other problem. You've moved other people in the landlord doesn't know about, there's drug dealing going on, something like that. Well, actually, that's a bad example because there's also a special rule if there's drug trafficking happening, and that's no notice is required. You just give a notice that the tenancy is terminated immediately. The notice requirements imposed by state law, the notice requirement can be waived if the parties agree to it in the lease agreement. It's a pretty high standard for a waiver. The tenant has to intend to give up the notice that the tenancy is terminated.
Okay. One of the things that we hear about from time to time is what lawyers sometimes refer to as self-help, where someone doesn't use the judicial process, but they take action into their own hands. They take the law into their own hands, if you will. And this would be a landlord who basically puts a padlock on the door, say, you didn't pay the rent today, I'm not letting you back in the apartment, I'm going to take your furniture or whatever.
Right.
Are there rules against certain types of self-help?
Absolutely. And Mid-Penn Legal Services, we're a legal aid office. We represent low-income individuals. And very few other things create kind of quite as much excitement in a legal aid office as when we hear about a self-help eviction. It's well-settled law that you can't use self-help measures to end a tenancy. And these include padlocking the door when the tenant's out, or even cutting off the utilities, cutting off the electricity. Part of the rationale for that is because the statute, the Landlord-Tenant Act in Pennsylvania, creates a remedy that's very efficient. It's a summary proceeding in nature compared to other sorts of legal actions. From start to finish, it can take as little as 38 days after the notice has been served.
This judicial proceeding would be in front of a district magistrate, district justice court?
Correct.
Okay.
Correct.
Now, there is an appeal right before the Court of Common Pleas. Am I correct on that?
Well, that's right. The way the timeline goes is after the notice period expires, and the tenant hasn't moved out, the landlord then goes to the district justice court, makes a complaint. This is all done on forms established by the lower court rules committee. So it's district justice courts in Pennsylvania are the small claims courts. They're set up to function without lawyers and somewhat informally. The complaint is served to the tenant by the district justice court by both mail and personal service. And then a hearing needs to be scheduled, no fewer than 5, but no more than 10 days after the, no fewer than 7, no more than 10 days after the complaint is filed.
Right. And during this process, during this period where there's a required waiting period, the landlord is not allowed to use what we call self-help.
That's right.
And the tenant might have a defense, even if the tenant does not have a defense, the tenant is still entitled to that time period to get his or her affairs in order, basically, even if they have no defense for not paying the rent, if you will.
That's right. So then the hearing takes place before the magisterial district justice. The district justice will issue a decision either dismissing the landlord's complaint if no cause is shown. The other possibility is the landlord prevails. There's a judgment for possession. There can be often a claim for damages. Well, certainly if it's a non-payment of rent case, the landlord can get a judgment for the rent that hasn't been paid.
But they could also be for damage done to the unit, for the apartment.
Correct. And then you asked about appeal. There is an appeal that can be brought within 10 days of the decision. If an appeal is not made, the judgment, at least for possession, becomes final. And then the next step in the process is the landlord, if the tenant still hasn't moved out at this point, the landlord contacts the district justice court and says they need to have the order of possession enforced. The order of possession is then served to the tenant, and that schedules the eviction for 10 days after the judgment for possession has been served.
So what you're telling us, eventually the tenant will be forced out if the tenant does not leave during this process.
And it's pretty uncommon that a tenant wouldn't move and stays to the bitter end. But if they don't, the constable from the district justice will come out at the appointed time and is authorized to break in if necessary and restore the landlord to possession.
So far what we've talked about is the remedy that would be available to a landlord if the tenant isn't living up to his or her end of the bargain, mainly paying the rent.
Right.
But what happens if the landlord's not living up to his end of the bargain? The landlord is supposed to provide an apartment that's habitable, that's in good condition. There's something that I believe from law school, as I remember, it's called the implied warranty of habitability. Could you tell us what that is?
Correct. The implied warranty of habitability is kind of a modern recognition. Most every state's through case law adopted one of these. They came about in the 1970s. That for we were talking about residential apartments only, but when an apartment is rented, you're not just getting the dirt. You're getting something that's livable, something habitable, something that's secure, has proper ventilation, has decent heat, major plumbing, keeps out the weather, no leaks to the roof. It doesn't have to be in the contract. It's implied in every contract. So the landlord has an obligation to provide a housing that's livable.
Well, let's say, for example, it's the winter time right now, and there is no heat working in an apartment.
Yeah.
What is the tenant to do?
Well, the tenant has a variety of remedies, but the most important thing to do is to make sure that the landlord has notice of the problem. Landlord can't fix something that the landlord doesn't know about. We certainly recommend that notice be made in writing to explain what the problem is. The landlord then has a reasonable period of time to remedy the problem.
And
before the
reasonable
tenant
time
can do
would
anything.
depend on the circumstance. Heat in the winter would be a short amount of time that would be reasonable, whereas the furnace not working in July might not be a big deal for a month or so.
I'd say rule of thumb is if anything that goes to habitability is significant. If it's heat in the wintertime, then within 24 hours is a rule of thumb. Major plumbing, other things, probably it's variable, but 72 hours is a rule of thumb I use. But then the question is, what are the tenant's remedies? Well, if that reasonable time has passed, a day, and the landlord doesn't respond, the tenant has a variety of remedies. One thing the tenant can do, if they decide, is the tenant has the right to terminate the tenancy at that point.
So even if the tenant signed a one-year lease and there was no heat provided after a reasonable amount of time in the winter, the tenant might say, I've only 3 months in the lease, but I'm not staying here anymore. You can't make me pay any more rent because you're not providing heat.
Correct. The tenant has that right to terminate the contract for that material breach by the landlord.
Now what happens, and I know this is a problem, the tenant can't find another place to go and the tenant is still stuck in this apartment without any heat. What else can the tenant do?
Right. And we see these situations, and they're difficult. The tenant has the right, if the landlord's not responding, to what we call repair and deduct, basically fix the problem themselves. If they're competent to do it, it's not something that requires licensing certification. The tenant could attempt the repair on their own. More, we recommend that the person have a professional do it.
So if it costs $500 to fix the furnace, the tenant could literally pay the person to fix the furnace, assuming it's a reasonable fee, and then not pay $500 out of the rent for whatever period $500 would be in the rent.
Correct. And we call that remedy repair and deduct. Then when it's time for the tenant to pay rent the next month, they would provide the proof of the repair, and then the balance, whatever the difference is between that and the rent.
Now, I also heard that a tenant can put money in escrow instead of giving it to the landlord if the landlord is not providing a habitable residence, if you will, or there's damage.
And this is a point of confusion, because to avail yourselves of your rights under the implied in law warranty of habitability, there's no requirement that you escrow. There's no requirement even that the tenant be current in rent.
Okay.
That doesn't alleviate the landlord's responsibility to provide habitable housing.
So the landlord cannot retaliate against non-payment of rent with not furnishing vital services such as heat, electricity. Is that?
That's exactly right. That's
that would
exactly
still
right.
violate the implied warranty of habitability.
The landlord has the remedy if there's non-payment of rent or another breach.
We have very little time left, Ben, but I do want to ask one more question, and that is, if someone is having trouble with rent in these hard economic times, is there a place where they can get some type of assistance?
There is a rental assistance program. Currently, it's being administered by CPC, and their number in York is 717-845-7176. There are limits. Typically, what the tenant has to show is that they didn't cause the problem that caused them to be behind in rent. They lost the job.
Thank you. We're just about out of time. Today's guest was Ben Hooper. Our topic was our topic was landlord-tenant law. Ben is from Mid-Penn Legal Services. Thank you.